We're going to be talking about negotiating business and human rights at the United Nations. And that Dr. Claire Methven O'Brien is a strategic advisor and a senior researcher with the Danish Institute for Human Rights, a Baxter Fellow and lecturer at the University of Dundee School of Law. You're internationally recognized as a human rights scholar and an expert and an advocate focused on, among other things, business and human rights, mandatory due diligence legislation, and the United Nations, like as this talk will be about, European Union and Council of Europe. Welcome. Should I say Claire? Should I say Dr. Methven O'Brien? What works for you?
Claire is fine.
Thank you, thank you. Hi, Claire, welcome, and we're really looking forward to your talk. This has been an event of over 100 different events and activities. We're recording everything. I'm sure you're okay with that. We will be broadcasting it more often, and we'll be sharing that recording with you so that as many people as possible can hear your presentation. But thank you for being here and welcome. And I'm really curious where you're going to take us.
Well, thanks, Kareem, and of course, for the invitation. Can you hear me?
Yes.
Yeah. Well, I'm speaking from the northwest coast of Zealand in Denmark, beside the sea. It's good to be with you all this evening. I'm going to talk a bit about a current process in the United Nations to negotiate a business and human rights treaty. Of course, the background and context for that is that since 1945, through the United Nations system, states have transacted international agreements to protect the dignity and fundamental rights of all of us as individuals, which include the International Covenant on Civil and Political Rights, the Covenant on Economic, Social, Cultural Rights, and a number of other treaties that deal with the rights of specific groups like children, people who belong to racial or other minorities, women, and persons with disabilities. Historically, also it's been the case that the duty bearers in relation to human rights have been states, in line with the general structure of international law, which originally recognized only states as parties, and to a large extent still does. States were thought to be and of course in the context of the Second World War, had been the sort of principal threat to the freedoms and dignity of individuals. And gradually in the subsequent, decades, last part of the 20th century, and certainly first decades of this century, it's been increasingly recognized that private actors, corporate actors, businesses can and do have as damaging consequences for people's enjoyment of human rights as the state in many instances. So what to do about that in terms of international law? And that question has attracted initiatives, discussion, diplomatically through the UN system, also among scholars, of course, analysis, debate, proposals, and that discussion is not yet concluded. There have been various chapters so far in the 1970s in the context of the new international economic order movement, when newly independent states sought to assert themselves and sort of rebalance power and legal relations that had weighed in favor of colonial powers through the United Nations system. There was an initiative to try to make a code of conduct for transnational corporations, because transnational corporations were seen at that time and legitimately as instruments through which value, wealth, and power were extracted from formerly colonized states by colonizing powers. And that initiative wasn't ultimately successful. Human rights wasn't the primary focus of that initiative. They were sort of marginal to it, but so for other reasons, really, it wasn't successful in the 70s and 80s. Of course, globalization, you can say, continued to accelerate in the 1970s and 80s. You have sort of mega trends of liberalization of financial flows, in accelerating communication, transportation, flows of information, capital, and so forth, really intensifying over that period, and removal of barriers to trade, capital controls, and so forth over that period. So, and at the same time, you have the trend of offshoring, the development of global supply chains, integrated supply chains, the sort of substitution of these models of co-production for traditionally vertically integrated companies, you know, classically like the Ford Motor Company, producing everything sort of in one place. Now you have hundreds, thousands of suppliers making a single laptop computer or personal electronic device distributed right across the world, global value chains. And with that came growing awareness of, you know, the consequences, the uneven distribution of the environmental and social consequences of these forms of production, in the form of environmental and human rights abuses, sweatshop labor conditions all around the world, and so forth, and increasing activism around that. And that, you know, was along with the sort of movement to resist further liberalization of international trade, the movement against the WTO in the 1990s, the Battle of Seattle, and the no logo. This was the moment of no logo, and Naomi Klein, and lots of activism around these adbusters, lots of activism around these issues. There were additional moves to try to mobilize human rights law to address this problem of increasingly powerful corporations beyond the control of any one state, who at the same time had significant and very extensive impacts on health and safety, basic health and safety rights, access to clean water, environmental damage of other kinds, oil pollution. So how could the international human rights system, which was supposed to guarantee, you know, these basic things for everyone, how could it respond to that challenge of the power of global multinational enterprises? And the UN Subcommission for the Promotion and Protection of Human Rights, under the Human Rights Commission at that time, developed a set of draft norms on business and human rights, which tried to give companies sort of analogous human rights obligations as states. And that initiative was resisted by states, and yeah, opinion, let's say, amongst scholars and international lawyers was mixed as to whether, you know, whether it was desirable, whether it would be meaningful to try to give private actors the same sort of scope and type of obligations as states. So that didn't succeed. Kofi Annan, as Secretary General of the United Nations, then in the 1990s, tried sort of as part of the movement towards a, you know, a fair globalization, and a reanimation of human rights in the context of globalization, set in motion the establishment of the UN Global Compact. So this was a sort of voluntary set of, you can say, CSR, corporate social responsibility standards for companies, which eventually included references to human rights. And then he also asked Harvard professor John Ruggie to try to pick up where this previous unsuccessful initiative on the UN draft norms, where that had left off, and try to, you know, figure out how can we move forward on this in a way which is still acceptable to states and to businesses, and that is meaningful within the sort of confines of the state-centric paradigm of international law. And that process led to something called the Guiding Principles on Business and Human Rights, which reaffirm the state's duty to protect all of us against human rights abuses by business actors, and then affirm the responsibility of businesses to respect human rights. In other words, do no harm to human rights, which they should implement by a process of due diligence, which means having a policy on human rights that they will uphold and respect human rights, undertaking human rights risk assessment, applying measures to implement the findings of that risk assessment, and remediating any human rights impacts that they might be involved with. That's the second pillar, so-called, of the UN framework on business rights. And the third one is a reassertion of the right to have an effective remedy against business-related human rights abuses, whether that's provided through courts in the normal way or through non-judicial grievance mechanisms. So this was the 2008 UN framework. It was further elaborated in 2011 by a set of guiding principles, which were unanimously endorsed by Human Rights Council at that time. And subsequently, UN guiding principles have been widely acknowledged, referenced, internalized by companies and international financial institutions, civil society, national human rights institutions, and also national governments. So there's been a very successful sort of approach in terms of addressing this problem of business human rights, but they have been felt not to go far enough by some parties. Some states, civil society, would prefer to have a so-called binding instrument. In other words, a treaty. So the guiding principles are not themselves articulated as an international agreement. They're a soft law instrument, and some parties still feel that there is a need to have actually something on an equivalent level to the existing human rights treaties, but which addresses this topic of business human rights. Some people would like that treaty to still give corporations human rights obligations directly enforceable, either by some new international body or perhaps through international courts. And this led Ecuador to, with the support of a smaller number of states, to launch a sort of second initiative to have a UN treaty on business human rights in 2014. And that was through a Human Rights Council resolution. A mandate was established to have a process to negotiate an international treaty on human rights and transnational corporations and other business enterprises. And this was quite divisive in the Human Rights Council at that time. Can't remember the exact numbers, but there was a sort of almost even split on Human Rights Council between countries that were in favor of this mandate and those that were against it. In any case, the last 6 years has seen a process unfold where Ecuador as chair has advanced a number of the Intergovernmental Working Group, as it's called, a number of drafts of a treaty which would address this topic of business human rights. So, this of course is, I think, in general, an important challenge for the international human rights system, for its relevance today in the context of still intensifying globalization, the let's say accentuating inequalities within countries and between countries, where corporations are certainly instruments or vectors of that dynamic. We have seen, just as one example in the context of the current pandemic, the wealth of large corporations and the individuals who own many of them balloon hugely, and the numbers which are produced by Oxfam every year on how much of the world's wealth is owned by so many people keep on sort of deteriorating. A smaller and smaller number of people and corporations own more and more of the world's wealth. And I don't think there's much controversy really today amongst economists or even politicians that this is not a healthy dynamic for humanity at a global level. This is implicated, this dynamic, in our failure to be able currently to address, the existential crises of climate change, amongst others, that we're at loss of biodiversity and so forth, that we're all facing. So this is a kind of critical challenge for the human rights system to address. However, it's a difficult issue, I would say, and people do have different views on this, to do it in the way that's currently being proposed, because if you want to do something, if you want to address this problem through the medium of law, of international law particularly, and more specific international human rights law as a branch of public international law, then you do face certain constraints in terms of the medium, that using that medium, and it's, I would say, not possible to sort of through a single treaty to radically re-engineer the conceptual structure of human rights law on multiple fronts in one go and still bring states with you in terms of their support for the resulting instrument. States have a vested interest in preserving certain aspects of the structure of international sovereignty, for instance. Very few states are sympathetic or enthusiastic about adopting instruments which would radically curtail their sovereign power. So that means, and neither do they want extraterritorial obligations in relation to human rights, which are massively more extensive than their current obligations, and neither does that fit very well with the way human rights operates outside the business and human rights space. So there's lots of difficult conceptual and doctrinal challenges to trying to, I think, have a treaty which, for instance, imposes direct legal obligations under international law on transnational corporations or other business enterprises for human rights law, for human rights abuses. Another problem is the issue of shared responsibility. So into general international, and I guess I'm speaking, I'm assuming here I'm speaking mainly to lawyers who will be familiar with some of the undertow around these issues. But shared responsibilities in public international is an area which is still quite emergent. So what does that mean? If you imagine a scenario where you have a company where the host, where the parent company is in one jurisdiction, the supply chain, of course, traverses a number of other jurisdictions. So maybe then it's a supplier of a supplier to the parent company whose conduct has caused human rights abuses. So it's maybe in a third or fourth country. You have, of course, chain of causation there. And you have issues because of that around foreseeability. And you also have a sovereign state, which is responsible in human rights law for regulating through law, through policy, through enforcement agencies, what happens in the country of production. So in public international law, there's a question mark. Okay, how do we allocate or divide and parcel responsibility for human rights abuse in that scenario, as between the state where the parent company is based, the state where the intermediaries are based, and the state where the company actually responsible for the abuse is placed. Between those states and also the companies, becomes a very complex analysis to try to figure out how to allocate and divide responsibility, where you have maybe multiple sovereign states simultaneously being a duty bearer in relation to human rights. So I see that there's lots of difficulty in trying to establish these sorts of obligations for states and companies at the level of international law. I think it's quite okay to use existing sort of standards and norms of transnational private litigation, you know, transnational tort claims. It's quite okay to try and use those mechanisms that already exist to give money, you know, a remedy in tortious damages, financial remediation for victims, where, you know, where they already meet the normal standards of foreseeability, causation, reasonableness, and so forth. But trying to do it through international law becomes a very, you know, I would say incoherent project. So what I have proposed instead, and I published a draft text for a business and human rights treaty in the sort of style of a framework convention, is for a treaty, business and human rights treaty, which would rather establish general obligations for states of more of a procedural character, that they have to progressively continue to evaluate, monitor, improve the extent to which they give effect in national municipal law to the existing UN framework, the state duty to protect, corporate responsibility to respect, and the right of victims to remediation for business-related human rights abuses. They have to develop and implement national policies, plans on business and human rights, again, progressively to advance protection across those parameters. And then, you know, set up a conference of parties to this treaty, which would have the power to adopt a different sort of a diverse set of subsidiary instruments. Could be additional protocols, could be formal guidance, could be setting up multi-stakeholder advisory or technical committees, so that you can really, or developing model laws, so you can really still address the different problems that we have, the different gaps in protection around business human rights issues, but do it, you know, not all of it trying to get it in at the level of the treaty, but at the sort of appropriate level of normative articulation, because some things are just better done through subsidiary instruments. And, you know, besides that, it also means that rather than transacting a single standard which all states have to accept before they can sign the treaty, you have a relatively, you know, low threshold for signing the treaty, and then the details are worked out later. Because I think the history of other human rights treaties shows us that what's key is to get consensus on the broad principles, and then the way they're amplified and filled out later on sort of gives the treaty its bite. So that's really, yeah, that's the model I've advanced. I can, you know, send a link to that afterwards. And yeah, and I'm excited that some states are now showing interest in that, because, yeah, to go back to the current process in the UN, you know, it's sort of at impasse. It's sort of at impasse. And, you know, I think this is a stalemate that we, you know, globally, and as lawyers, as human rights advocates, as citizens of the world, you know, we can't really afford to have this issue not addressed at the global level. You know, if we don't have a global treaty on business and human rights and a global forum, there are some problems that, you know, will not be acknowledged, will not be responded to. You know, who's calling Facebook and Amazon and Microsoft to account if there isn't a you know, for their impacts on human rights, which are dispersed across the world. If there isn't a forum with the moral authority of the UN who can call on them, you know, it's difficult enough to get them to show up before Senate and so forth. So, you know, we really need that forum where we can bring together the voices of everybody who's affected in the world to show that, you know, this is not an issue just for people in one jurisdiction or regulators from one jurisdiction. You know, this is about the obligations you know, companies owe to all of us collectively as humanity.
Wonderful. What an incredible proposal, and what an incredible story in the history of history, and the historic story of the development of human rights in business and business. We have 5 or 10 minutes left for questions, and there's some of us in the room. I could start us off, and if you have questions, please, if you have them ready, please unmute yourself and maybe show your video. What right away, what reminded me, I want to start at the end. It seems your proposal for this new treaty builds on similar mechanisms that I recognize from the Paris Climate Accord. Have you taken inspiration from similar accords like that?
So there are a few agreements, which have sit under this sort of umbrella of framework conventions. The WHO, the World Health Organization Framework Convention on Tobacco Control is one. Paris Climate Agreement, as you've said, and there are the Convention on Biodiversity. So there are a few which adopt this model. So yes, to some extent, there's some modalities that I think are very illuminating to consider, which can be drawn from those other. Not to say that any of those or all of those other agreements work optimally, but certainly there are experiences to draw on. However, in general, I would say it's also really the model of human rights treaties, as such. They don't get called framework conventions, they get called human rights treaties. But, there are a number of scholars who've looked at the way that they have effect. Of course, there's some debate amongst scholars of different, political scientists, international relations, so forth, but do human rights treaties make a difference at all? And some people have tried to say, they don't make a difference because there's no correlation, linear correlation between states ratifying human rights treaties and human rights violations decreasing. However, to my mind, this radically oversimplifies, the project of human rights and how they do actually have traction in society over time. And some of those scholars have also pointed out that, by their very nature, human rights treaties, the instruments, the texts, are open-ended, they're purposive. And that's actually essential when the subject matter is so broad-ranging by comparison with other types of international treaties, which often have very narrow subject matter. Human rights are all-encompassing. That's the whole point. They can penetrate any and all points of social relations, market relations. That's their function, to destabilize existing forms of law and substantive legal principles. So it's essential that they're actually broad-ended. And what happens later, and you can see this with the human rights treaties, is that the details are filled in as time goes on by treaty monitoring bodies, through guidance, and through the process of dialogue between states and supervisory bodies, informed also by inputs from civil society organizations and other actors. So, to me, this is actually a model which is faithful to existing human rights treaties. And the current model that's on the table looks more like an international private law convention, very specific in its terms, asking states to do very specific things on, the processing of transnational private tort claims. And yeah, that I think will not work. Too much diversity in national legal arrangements, amongst other things, for a sufficient number of states to be able to sign up to start with.
It triggers once again another question, and again to the audience, please, if you have one, do interrupt me. But and or put yours in the chat, and we'll follow up with that. But what it triggered with me is that we on day one we had a presentation from Jeremy Lent, and he's written this incredible book, The Patterning Instinct, and one slide he showed us, it was that 69 of the 100 biggest economies in the world are corporations. Then today there was a presentation from Karen Ism, and she has the Future of Governance Agency, and she talked about corporate dictatorship, where I was worried about rising authoritarianism within our existing democracies in the world. I was talking about actual dictatorship is actually the governance principle within corporations, and these And if I put those two facts together, how do we start regulating that? And I'm curious, how does your proposal, when it seems to be focused at nation state action, how does your proposal start to address the fact that 69 of the biggest economies in the world are actually corporations, the power that they have to affect our lives? If you look at the 10 biggest, they're all data-based organizations. How do we even start to get a handle on that if progress at the UN level in all-encompassing treaties is so slow?
Yeah, excellent question. And I definitely accept that, the data that you've just presented weighs in favor, as do other data, of trying, of the idea that it's important to try to tackle individual companies directly and to make them, duty bearers, to acknowledge, look, they've got all this power. It seems kind of logical to try to fix them with obligations directly rather than through the sort of more circuitous route of the state. But I guess, there are a number of answers or responses to give to that. One is that, which I haven't spoken very much about in this session, but I did mention the second pillar of the UN framework, the corporate responsibility to respect human rights, is not as such a legal principle, but it's the implication of existing legal principles. And as I said, companies are intended to operationalize that responsibility through this process of corporate human rights due diligence. Now, actually, what's happened, and this is a construct which it does emerge as such in the 2011 guiding principles. This concept has actually already found its way into legislation in a number of European states and in the United States in a softer form. And is actively under consideration as the sort of centerpiece of new European Union legislation. So this legislation would give companies of a sort of scope still to be determined, which companies, all companies or just large companies, but would give them an obligation to do process of human rights due diligence. And that means, as I said, that they have to actively identify what are the risks they pose to human rights. They have to then take measures to mitigate it, address those impacts, and report publicly on what this whole process. Now that itself, I would say, kind of owes its DNA to ideas about reflexive law. We could talk about this, for much longer, of course. And the idea of kind of constitutionalizing the corporation through procedure, which demands that it interfaces with, stakeholders, or in the case of human rights holders, in a structured, ongoing process. So that's the way of getting the company, the open corporation and other, writers, getting the company to sort of structurally, it does go, to corporate governance principles, and would entail actually a kind of evolution, I think, from corporate dictatorship to a more sustainable form of company, in which workers, locally impacted rights holders, and also consumers and other service users are sort of integrated into the knowledge machinery and the policymaking machinery of the company. So that's kind of the end point, the vision. Now that's very imperfectly implemented, realized for now. And even the legislation that we have on the table now doesn't do that by any means perfectly, but it's, it's a step on that road to sort of transform. It does have transformative potential, I guess is what I'm trying to say, in that it enforces this sort of self-knowledge process on companies. Now, I don't think that really makes it's not going to have the level of desired or the depth of desired impact that it needs to have to avoid the situation where we're now in, or to really get us away from that situation where corporate power and wealth is concentrated in huge corporations, and they're also, sort of dictatorially driven. But if you combine it with other kinds of enhanced accountability and governance reform, then maybe you start to get to that destination. And I don't really, I don't see a better solution right now, because probably we can't, we can't have a counter sort of capitalist global revolution. Elements of this have been tried before. So I guess I'm more, hopeful that moving on this trajectory can deliver kind of more sustainable change in the right direction.
Our time is actually up, but maybe we can do one more question. And I'm not sure how much you've been told about the summit you've been invited to, and the collaborative that is emerging out of this. And but just to share a little bit with you and with others at home, what we're aiming to do is obviously create these, or obviously what we're actually aiming quite ambitiously to do is create these transnational, interdisciplinary, networked communities of practice that work together around different issues in the law, and from all across the world. So if you'd imagine that we have a network community of practice working on this issue of business and human rights, and pushing for this very specific intervention point, or very broad, at the same time, far-reaching intervention point of this treaty that you're proposing, how can we, as a community of practice, help you from our different jurisdictions? How can we come together and leverage or lobby, or maybe even do some litigation to help the reality emerge that you're fighting for? Because you're an advocate as well.
Yes, I am. Yeah, currently advocating in the context of this treaty process. Yes, a lot of just to acknowledge, of course, there are many civil society organizations active in this area already and doing, essential work in collaboration with affected communities, with trade unions, also as agents of that discussion. So there's a lot going on, which is important for anyone who's considering to sort of enter the field to already tap into, and certainly to collaborate with grassroots organizations, or international NGOs. I think that would that's a very good first step. But also from the point of view of your expertise on the law in your own jurisdictions or in your specific areas of specialization, I think, considering these issues from that perspective, writing about, some of these these challenges, these doctrinal challenges, considering these thought experimenting around these problems and dilemmas, that's all very useful. And more concretely, looking at the draft treaty text, well, my own, but also the one which is currently promoted by Ecuador as the chair of the International Intergovernmental Working Group, considering possibilities for mandatory human rights due diligence legislation in your own jurisdictions, using the models which are already circulating from France, the Netherlands, and there are proposals in a number of other European countries, Switzerland, Germany, and Finland also. So, informing on these different legislative proposals, I think all of these things, and then, considering what else needs to change in terms of corporate governance, responsibilities of investors. These are all very interconnected, non-financial reporting, these are all very interconnected, and certainly, capacity of the legal profession. And there have been some interesting, initiatives by the International Bar Association and others, where they've tried to also think through what are the implications of the UN guiding principles for us as legal professionals who are in the business of, advising companies. And there's a lot of capacity building to do their reflection. None of those things will be, dealt with overnight. Or with ease. So engagement on any of those fronts would be very worthwhile.
I'd love to hear if there's any low-hanging fruit. We don't have time for it, but there is one question in the chat And before we go to that question, we'd also love it if you would be willing, I think you spoke of an article or you were willing to share something with us. Maybe you can share the link with us in the chat.
In the chat.
In the meantime, that would be great. And we'll spread it around. But Michael, do you want to ask the question yourself, or should I go for it?
Yeah, you can go ahead. But what I meant is that given all these issues that you said, do you think a World Data Organization might help, resolve this matter?
So could you tell me what that would do? What do you think would be the kind of possible role or value? I'm not sure what a World Data Organization would do exactly, but maybe could you tell me how you see it connecting?
I think it's more of an organization that defines what constitute data rights, individual data rights, to how individual or private data should be managed for each individual in every country.
Okay, yeah, I get it now. Yes, I mean, I don't know specifically on that proposal how that could play in. I think the issue you're pinpointing is a crucial one. I think we're probably all basically now aware of surveillance capitalism and the fact that all of our personal and private data is being gathered and monetized. So, in ways which most people are just not aware of, and which possibly does have a corrupting influence on the institutions of democracy and, and the very fabric of our society. So, the issue is an absolutely crucial and central one, I think, for a business human rights treaty to confront, which is partly why I favor this broader model of framework convention, because I think, that has to be within scope for this discussion and for these norms. So narrower instruments, which are more kind of tailored to environmental damage and so forth, are really, really important that those issues are addressed, but we can't lose sight of the sort of current and the future threats of corporations to human rights, which revolve very much around, I think, what you're also signaling in your comment.
Great, thank you. Is there any other burning question from the audience? I know I have one more, but if you'll let me.
Yeah, sure.
How do you combine being an academic and an advocate? And what I mean by the question is, academia can be okay with progress being slow. And especially, with regards to the issue area you care so deeply about, it seems you gave us such a long the whole history of it. How does it make you feel when the progress is slow? But how does the activist in you deal with that?
Yeah, it's a good question. I mean, I guess being an academic, of course, you have a chance to also look backwards, when you're teaching, as I'm doing currently, human rights law to students, is incumbent on you to look backwards over time. And that, of course, is very reassuring also, in the sense that things took a long time. It took a long time to get where we are today. You're talking 10, 20 years to get from the Universal Declaration of Human Rights to the key covenants. Now, so to my mind, when I look at that, I think, okay, 2011, we've got this, in some ways very revolutionary sort of statement that, the private sector can have human rights responsibilities, and that states are also possibly having their sovereignty restricted with reference to human rights standards. These are quite, they're tweaks, you can say. They're small tweaks to the matrix, but they actually, the way they will reverberate can be quite profound. So I guess I reassure myself with those things, that in my lifetime I've actually seen you know, quite a lot of change, or at least the foundations of change. So that's how I kind of, yeah, I think I live with it.
That's wonderful to hear. You said you've made some progress already on the treaty. You said some states had adopted it even?
Well, they haven't adopted it.
Or
yeah, I mean,
it?
I did speak at a meeting on Friday, which was hosted by the United States and Japan, you know, just to discuss alternative approaches to the, you know, to the Business Human Rights Treaty. So, you know, you can, and that was well attended by other states on a cross-regional basis. So, you know, I hold on to that sort of in an optimistic way, even if, on the other hand, the sort of diplomacy around the current initiative has not been very impressive, in the sense there is absolutely a lack of leadership. You know, politically, there is a lack of leadership in the world on human rights issues right now, or at least on business human rights issues, and the dynamics are, you know, are dysfunctional in many ways at the international level. So it's, you know, it's, that's sad, and you know, you would expect more, I think, from humanity at this stage of our development than, you know, these kind of classic stalemate positions are just allowed to. You know, we can definitely do better than that.
For sure.